my name is Meaghen Russell, and I'm a partner in the Toronto Employment and Labour Group at Dentons, Canada. Today, we will be kicking off a new global employment law series called World at Work, Half-Yearly Employment Law Highlights. We're starting this series today in Canada as the first segment in this global series where Dentons employment law colleagues from around the globe will be discussing the top 5 employment law highlights from the first 6 months of 2023. I am joined today by my colleague in Toronto, Claire Browne. Hi, Claire. Thanks for agreeing to talk to us today about what's been happening in Canadian employment law during the first half of 2023.
Hi, Meaghen, and thanks again to all of our viewers that are joining us today.
So, Claire, we're starting in Canada. Let's move to British Columbia. What can you tell us about the new Pay Transparency Act in BC?
Yeah, absolutely. So the new Pay Transparency Act in BC imposes limitations on employers during the hiring process, imposes obligations with respect to reporting pay, and creates the role of the Director of Pay Transparency. In particular, there are 4 key obligations that we thought we would flag. The first piece relates to pay history, or in other words, prohibiting employers from asking job applicants their previous pay rate. The second piece relates to a requirement for employers to include expected pay or pay ranges for publicly posted jobs from November 1st of 2023 onwards. The third piece relates to pay secrecy, or in other words, prohibiting employers from disciplining or otherwise harassing employees who ask about their pay, reveal their pay to another employee, ask their employer about its pay transparency, or give information to the Director of Pay Transparency about their employer. And the last piece relates to a pay transparency report requirement. And this requirement only applies to certain applicable employers, and those employers at present include the government and specified Crown corporations. The obligation relates to a requirement to post pay transparency records, and those records will be posted annually on June 1st by the Ministry of Finance. As of November 1st of next year, or 2024, the definition of applicable employers will be expanded to include all employers with 1,000 or more employees. And by 2027, the definition will be further expanded to include all employers in British Columbia.
Thanks, Claire, for that overview. So in terms of next steps for BC employers, what should they be doing to ensure that they are complying with this new legislation?
Yeah, so it's interesting. At present, the Act doesn't set out any sort of penalties or enforcement mechanism. However, we expect and anticipate that the enforcement mechanisms that are set out under the British Columbia Human Rights Code will also apply in this circumstance. So we encourage employers to make sure that they're taking the necessary steps to confirm that they're compliant with these new pay transparency requirements, as well as any best practices that relate to these requirements, as we anticipate that over time, there will be increased scrutiny that's placed to these requirements and complying with them in the coming years.
Thanks, Claire. Now moving east to Alberta, please talk to us about the Alberta Health Services case from earlier this year.
Absolutely. So in the Alberta Health Services case, the Alberta Court of Queen's Bench recognized an independent tort of harassment for the first time. Prior to this case, Alberta courts rejected the notion of harassment as an independent cause of action for civil claims. And the main recourse that was available to employees who experienced harassment for reasons related to a protected ground under human rights legislation was through the Alberta Human Rights Commission. Employers were also able to file workers' compensation claims if they were in an industry and occupation that was covered by the Alberta Workers' Compensation Act. And in addition, if an employee experienced harassment in the workplace, the employee could quit on the basis of a toxic work environment and commence a claim for constructive dismissal. However, the Alberta Court of King's Bench has now defined an independent tort of harassment, and this tort is defined as follows. The defendant has engaged in repeated communications, threats, insults, stalking, or other harassing behaviors in person or through other means that they knew or ought to have known was unwelcome, which impugned the dignity of the plaintiff, would cause a reasonable person to fear for their safety or the safety of their loved one, or could cause foreseeable emotional distress and caused harm. So this is a bit of a mouthful, but that is the new definition of the tort of harassment as articulated by the Alberta Court of Queen's Bench in Alberta.
So Claire, given the recognition of this new tort in Alberta, what would we recommend to our clients? What should they be doing? What should they be cognizant of when they're dealing with claims of human rights types of violations?
Absolutely. So from my perspective, this case reminds us, and it reminds employers, of the continued importance of promptly responding to and investigating harassments of or complaints of harassment or any sort of other human rights related complaints of discrimination, et cetera. And so we expect that, similar to the considerations that are raised by the Alberta Human Rights Commission when considering these types of claims, that an employer will rely on the fact that they conducted a thorough investigation and a proper investigation once they became aware of any alleged harassment in the workplace. And so again, just really emphasizing the importance of being prompt and conducting an investigation that is reasonable in the circumstances. And in some cases, that may require retaining a third-party investigator to conduct that investigation.
Great. So let's move over to Ontario. And in particular, I'd like to talk about the Aurora Hotel Group case. We have certainly been talking about this case within our own group, employment law group here in Toronto, because there's a number of significant takeaways that employers need to be aware of. So Claire, please give us your thoughts and talk to us about this important case.
Yeah, sure. So in this case, Justice McKelvey of the Ontario Superior Court of Justice reviewed a surreptitious recording, so a secret recording that was taken by an employee during their termination meeting. And in particular, Justice McKelvey highlighted a number of aspects that he described as disturbing about this particular employee's termination. So the first piece that Justice McKelvey highlighted was that there was no evidence that the employer provided the employee with written notice of termination of employment, as required under Ontario's Employment Standards Act. The second piece was that the employer failed to deliver the employee's entitlements under the Employment Standards Act within the requirements set out under the Act, which are 7 days after the employment relationship ends or by the next pay date. The third piece that Justice McKelvey highlighted was that the employer failed to provide the employee with expense reimbursements that were owed to the employee in relation to out-of-pocket expenses that were incurred on behalf of the employer prior to the termination of the employment relationship. And the fourth piece Justice McKelvey highlighted is that the employer told the employee during the termination meeting that the employee would receive 8 weeks of severance. However, despite this assurance being provided orally during that meeting, the employer limited the employee's termination entitlements to the statutory obligations under the Employment Standards Act, which were lower than the 8 weeks that was discussed during the termination meeting.
Great. So in terms of what we can learn from this case, what we can share with employers about, putting themselves in a situation where they're not going to be subject to moral damages, what would you remind and or recommend employers do in termination related meetings?
Absolutely. So I think the first piece is just reminding employers that written notice of termination is required under the statute. So it's required under the Employment Standards Act. So it's really important that you make sure that you provide that written notice of termination to employees. The second piece we would encourage employers to consider is to make sure that their termination letter templates cover off all of the employees' minimum entitlements under the Employment Standards Act. The third recommendation we would share is to make sure that employers are crystal clear during termination meetings with respect to what the employee can expect regarding next steps, as well as then following through in terms of making sure the employee understands where they can find the written confirmation of those details with respect to their termination and what they can expect right after their termination. And the last piece is we would recommend that employers make sure that they have some sort of checklist or document that explicitly sets out the steps that they must follow following a termination. termination, just to make sure that those steps are complied with and they comply with all of their statutory obligations. And on that piece, I would flag that our group very frequently provides employers with that type of guidance. We provide checklists and other types of checks and balances that can help employers. So I would leave that with viewers in case anybody needs some assistance and they want to reach out to our team.
So let's talk about another decision from Ontario that has been released over the last 6 months. And this is yet another decision dealing with the enforceability of termination provisions in employment contracts. So Claire, could you give us an overview of the StoStack decision and give us some recommendations or takeaways in relation to that decision?
Sure. And so in this StoStack decision, the Ontario Superior Court of Justice determined that the employee was entitled to common law reasonable notice of termination, as the with cause portion of the termination provision violated the Employment Standards Act, and therefore rendered the entire provision, including the without cause section of the termination provision, void and unenforceable. The termination provision at issue provided that the employer could terminate the employee without notice or pay in lieu of notice for any just cause. And the court concluded that the way that termination provision was drafted gave the employer the right to terminate the employee's employment without notice or pay in lieu of notice for just cause in a manner that could fall short of the statutory standard under the Employment Standards Act with respect to terminating employees without providing them with statutory pay or notice of termination and or severance pay if owing to the employee. Further, the court rejected the employer's attempt to rely upon the incorporation of the Employment Standards Act provisions into the without cause section of the termination provision to save the enforceability of the entire termination provision. The court emphasized, and I'll quote, as a result of the power imbalance between employers and employees, and the likelihood that many terminated employees may not be aware of or able to enforce their statutory rights, courts are especially vigilant to interpret employment contracts in a way that encourages employers to draft contracts that comply with their statutory obligations, end quote. And so from my perspective, this case reminds us again that in Ontario, courts are particularly scrutinous of the enforceability of termination provisions. And therefore, we encourage employers to make sure that their employment agreement templates have been reviewed by legal counsel and that any termination provision language has been revised where required to increase the enforceability of the termination provision as best as possible in the circumstances.
Great. So finally, as our fifth highlights covering Canada, let's move over to Quebec. And what can you tell us about this new act respecting the regulation of child labor in Quebec?
Absolutely. So Bill 19 refers to and proposes several measures concerning the regulation of work performed by children in Quebec. In particular, the bill amends the Act respecting labor standards to prohibit employers from having work performed by children under the age of 14. We do note, however, there are some exemptions under the regulation under the Act respecting labor standards that allows certain individuals under the age of 14 to work in specific industries, such as babysitting, homework assistance or tutoring, certain jobs in the artistic production industry, arts industry, newspaper delivery, childcare, etc. However, again, that exemption is also based on having parental authorization to perform that type of work. In addition, effective September 1st, 2023, children that are subject to mandatory school attendance are only permitted to work up to a maximum of 17 hours per week, or and including 10 hours per week from Monday to Friday. We note, though, that this prohibition doesn't apply during any period of more than 7 consecutive days during which no education service is offered to the child. In other words, a child can continue to work their summer part-time job or during the Christmas holidays, etc. This applies when school is in session, so to speak. The Act also proposes increasing the amounts of fines regarding contraventions of the Act with respect to work performed by children, and amends the Act respecting occupational health and safety to specify the risks that may affect, in particular, the health and safety of children who are 16 years of age and under. And so we just flag this update as well as a gentle reminder to employers to make sure that they're familiar with any specific additional legislative requirements that apply with respect to employees that are still in school.
Thank you very much, Claire, for that review and for providing those highlights across Canada over the first 6 months of 2023. So as mentioned, this is the first segment of a larger global series focusing on 5 key highlights in employment law over the first half of 2023. Please stay tuned for our second segment, where we will focus on these employment law highlights from the United States. Thank you very much.